Yes.
Bilang Miki semua daman ninda cibar.
No witness, Your Honor, today.
Yes.
If the one million was present, Your Honor. The other two, they are UTP. Rilang Miki and Shibor Lumdo are UTP.
Prosecutor Dilambang present. Accused Dilang Miki Smo and Shibor Lindo produced from Jelazar through BC. Accused Damon Mi Lindo present. Defense counsel CDR Lindo present. Record reveals that prosecution has not taken steps to summon the witnesses. Report reveals that prosecution has not taken steps to summon the witnesses. Prosecution shall ensure that witness is present on the next date fixed. Refix for evidence. Both the above accused persons are remanded back to 14 days judicial custody.
Ramesh Dekha, Sam Herkso, Saidulalan.
Here also no witness, Your Honor.
Accused Ramesh Dakar produced from Jelazar through BC. Defense counsel Srimati D. Strong present. Accused Sampher Ksu. Thonlang Surong are present. Who is appearing for the accused persons?
It is RB, Your Honor, for both.
Defense counsel is absent. Accused Saidul Alam Chaudhry is absent without any steps. Defense counsel is absent without any steps. Prosecution has not taken steps to summon the witnesses. Prosecution shall positively take steps to summon the witnesses. Refix for evidence. Accused Ramesh Dakar are remanded back to 14 days judicial custody. Issue bailable warrant against Saidul Alam Chaudhry.
Living Talang.
Here also no witness, Your Honor. Live in Talang.
But none of the cases you have taken steps to summon the witnesses. Why?
We did take step, Your Honor, in some of the cases, Your Honor. There are witnesses in this Karnel and Ramesh Dakar.
Accused Lavin Talang. Where is he?
Is present.
Present along with defense counsel R. Lindo. This court, by order dated 12/5/2026, has indicated that the witness, Dr. J. Manar, is pursuing his studies in Uttar Pradesh. The prosecution has not taken any steps to secure the presence of the witness. Prosecution shall take steps and ensure that the witness is present on the next date fixed. Refix for evidence.
Accused may step down.
Lewis, okay.
No report, Your Honor, on the summon issue to the IO, Your Honor.
Who's the
B shut up.
Why? Where is this B Sharap posted?
It's Nartiang PS.
Huh?
Nartiang PS.
Why no report? Where is this accused?
Accused is absent.
The accused Louis Mukim is absent. Defense counsel J.C. Darian present. Someone issued to WPSI B Sharap not returned. Prosecution shall ensure that the witness is present on the next date fixed. Refix for evidence. Prosecution to take fresh steps. Where?
Carmel Khan.
One witness is there, Your Honor.
Who's the witness?
Seizure witness.
Where?
He's the brother of the deceased.
Okay. Yes, next. Ramesh Dekha.
Ramesh Dekha.
Here one witness, Your Honor.
Who is the witness? For what?
He's the first person to discover the dead body and inform the admin.
Yes. Kuman Potmi.
Men Potney.
UTP.
What's this?
For evidence.
Yes. Yes.
Oh, evidence.
Kuman Potmi, produce Munjil Azad through BC. Defense Counsel, Sri T. Lambang present. Prosecutor, Additional Prosecutor, S. Chansang present. This is another case where the prosecution has not taken steps to summon the witnesses. Prosecution shall make sure that witness is present on the next date fixed. Refix for evidence. Accused remanded back to 14 days judicial custody. Yes, next.
Miguel Khan.
Yes.
This is for final argument, Your Honor. Leonard PP is indisposed, Your Honor. He's not keeping well. So pray for time, Your Honor.
Accused Mikhail Dakar present. This court has been informed that the PP is indisposed today. Defense counsel is absent without any steps. Refixed for further hearing. Yes, next.
Danibar.
Yes, for hearing on my petition.
Yes. Yes. Where's the petition? Yes. Yes, yes.
Your Honor, may it please, Your Honor.
Yes.
Filing this application under Section 3116 PC to support our witness, that is Dr. Sri IAS retired district magistrate. That the IO had charge sheeted this instant case on 22/2017 YCS number 19/2017, dated 22/2017 under Section 307, 326, 34 IPC, read with Section 25(1)(a), 1B outside. The IO during investigation has seized material weapon used in committing the crime, and after the same was sent to FSL Shillong. After the examination of the material exhibit by the FSL, a report was submitted by the FSL, which is on record marked as Direction 1. That in the instant case, arms were involved in the commission of the crime. As the IO of the case has sought for prosecution sanction under Section 39 Arms Act from the district magistrate for prosecuting the arrested accused persons, and the same was accorded prosecution sanction on 16/2/2017 under Section 39 Arms Act 1959 by the district magistrate and marked as an action 2. That for the interest of the for instant case, it is necessary to examine the district magistrate who had accorded prosecution sanction under Section 39 Arms Act 1959. I have given the particular of the witness, Sri R. Rathak, IAS.
Yes, yes. You got your point. Yes, madam. What is your response?
Your Honor, in this instant case, the accused was charged under Section 25(1)(a), 1B of the Arms Act. That is in contravention of Section 5, Your Honor. But Your Honor, Section 5 reads that whoever sell, transfer, convert, or has in possession for sale, transfer,
Give me the
or
answer.
conversion. Yes, Your Honor.
Yeah, please carry.
Yes. So on perusal of the evidence of the IO, both the IO, PW 10 and 15, Your Honor, the one SMBL gun was seized from the accused Matthias Liam. And even PW 15, who charged the case, he stated that the gun belonged to the accused Matthias Liam. So summoning the district magistrate would serve no purpose, Your Honor, and it would just delay the trial, Your Honor. Summoning the district magistrate would serve no purpose, Your Honor, because the gun belonged to the accused Matthias Liam, not Doniva.
What happened to accused Matthias?
He expired, Your Honor.
What do you say? Section 39? 39. Sanctions about only.
Previous sanction of the district magistrate necessary in certain cases. No prosecution shall be instituted against any person in respect of any offense under Section 3 without the previous sanction of the district magistrate. Section 3. Section 3.
Section 3, possessing the license without or possessing gun without valid license. Firearms and ammunition.
Have you gone through the reply file with it?
Yes, I've gone.
What do you have to say? Yes. With evidence. EW.
PW10 first IO. In chief at point number 11.
Yes. Yes.
Point number 11.
Read.
I seized one SBML gun from the possession of the accused Shri Matthias Liam and examined the sister witness Rosinawar and Rosalind Wang.
Air gun.
Yes, Your Honor.
It's air gun.
SBML gun.
Yes. 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 Yes.
And PW15. Second IO, he stated in his cross, Your Honor, it is a fact that at point number 7, the gun did not belong to the accused Donivar, but it belonged to the accused Matthias Liam.
Yes. What do you have to say?
Yes, Your Honor. Here in this case, these accused did not possess any valid license for having a gun. Therefore, this sanction is extracted. Therefore, arms act is attracted in this case. They did not have a valid license to possess the arms.
Okay. Next. What is the case? Why do you want this prosecution sanction? Where is the prosecution sanction? Where is the prosecution sanction?
I have attached it in my application here. Election too.
Then did you ask that question to the IO, that if the gun was seized from possession of this accused Malthias Liam, why did he ask for prosecution sanction for Doniwar?
No, your other I
Then it's okay. The defense, the prosecution has filed a petition. Why not register the petition? The defense has filed a petition number so and so under section 311 CRPC to summon inter-alia, praying for summoning Shri R. Rathap, bracket IS, retired district magistrate, who had recorded sanction under section 39 of the Arms Act 1959 for prosecuting the accused Doniwar, for prosecuting the accused Matthias Liam, and Doniwar. Stop. Copy of sanction order. May continue. Copy of the sanction order is annexed along with the application. Copy of the sanction order dated 16 February 2017 is annexed along with the application and marked as Annexure 2. Learned prosecutor submits that. The accused Doni War is standing for trial for an offence under section 307 stroke 34 307 stroke 323 stroke 323 IPC read with 25 bracket 1 hyphen small a close bracket again open bracket 1 hyphen small b Arms Act 1959. The prosecution has examined 15 witnesses accused examined under 313.
Not yet.
Thereafter, the prosecution evidence was closed and the matter was fixed, and the matter is fixed for examination of the accused under section 313 of CRPC. Full stop. At this stage, the prosecution noticed that arms were seized by the IO full stop. However, comma, the arm was seized by the IO. Arm was seized by the IO. And it was sent for forensic analysis the above evidence, the above facts was brought on record during trial. Full stop. However, the prosecution's sanction accorded under section 39 of the Arms Act 1959 inadvertently escaped inadvertently was not brought on record during trial. Full stop. Prosecution sanction under the Arms Act was accorded by the then District Magistrate R. Rapthap by sanction order dated 16/2/2017. Prosecutor submits that the ADM is a vital witness to establish that sanction was accorded to prosecute the accused under the Arms Act. Full stop. The prosecutor praised that the witness R. Rapthap may be summoned as a prosecution witness. Full stop. Per contra, learned defense counsel has filed a show cause to the application filed by the prosecution and submits that a prosecution sanction is required for prosecuting a person under the Arms Act only for an offence under section 3 of the Arms Act. Only in cases of contravention of section 3 of the Arms Act. Full stop. The accused is standing for trial for an offence under section 25 bracket 1A bracket 1B small letter 1A. Prosecution sanction is not necessary. Full stop. The defense has also contended that The testimony of PW10 and PW15 unambiguously reveals that the arms in question was seized from the possession of the accused of Matthias Liam, and it belongs to him. Full stop. The testimony of PW 10 and 15 does not warrant prosecution of the accused under the Arms Act. Full stop. The defense praised that the application filed by the prosecution may be dismissed. Full stop. Thereafter, hearing the contending parties, this court finds that the prosecution has made an application for summoning a witness at the fact end of the trial full stop. Section 311 clearly envisages that prayer for summoning a witness can be made at any stage of the trial the litmus test for invoking the power under section 311 is the satisfaction of the court that for a fair decision the litmus test for invoking the power under 11 is the satisfaction of the court that presence of the witness is necessary for the fair decision full stop. Nevertheless, the prosecution cannot wake up from slumber and make an application as and when they desire. Full stop. This is a case where the prosecution, before summing up the case, found vital witness was left out, compelling the prosecution to file the instant application. Full stop. The contention of the next paragraph. The contention of the defense that prosecution sanctioned under section 31 the contention of the prosecution that the prosecution sanctioned under section 39 of the Arms Act is essential for prosecuting a person who violates Section 3 of the Arms Act (1959) appears to be highly misplaced understanding of the penal provision. Section 3 of the Arms Act imposes a restriction in possessing arms, and Section 25 provides the punishment. Section 25 1B, capital letter 1B, subclause A distinctly reveals that any person who possesses or carry any firearm or ammunition in contravention of Section 3 hyphen shall be punished. No, colon after Section 3 shall be punished under Section 21 under Section 25 capital letter 1B. Full stop. The argument, it is reiterated, is on misreading the law. Misreading the law, comma, which is fundamentally it is reiterated that the argument of the defense is on misreading the law. And it has to be rejected at the threshold. The second contention of the petitioner that the testimony of PW 10 and 14 does not discloses the testimony of PW 10 and 14 discloses that the arms in question was recovered from the possession of a person other than the accused. The discloses that the arms in question was recovered from the possession of a person. Arms was recovered from the possession of the person other than the accused, and it belongs to and it does not belongs to the accused. Perhaps it may gain some weight during the final argument of the case. Giving any findings on the evidence, on the prosecution evidence at this stage would amount to deciding the cases in piecemeal. The prosecution sanction, which is appended along with the application, clearly reveals that the prosecution sanction was accorded for prosecuting the accused Malthias Liam and Donny Ward. Full stop. This court finds the examination of the witness are up to establish the prosecution sanction is necessary for arriving at a just decision. The prayer of the prosecution for summoning witness R. Rathab is allowed. Petition number so and so stands allowed to dispose of. Prosecution to take steps to summon the witnesses. To summon the witness. Petition number so and so stands allowed. Yes.
Bail application. Terminate.
Yes.
Yes.
Very good.
On last date, I had made a submission that I had filed this application under section 438 BNSS. So in connection with this session case number 14, 2025, Your Honor. So I think the case is fixed today, and there is one witness for this.
Yes, one witness here.
So you want to examine the witness and thereafter
We'll
take
hear,
up the bail application, or you want to take it up now?
well, we can hear the application.
Yeah? Okay, fine. Your Honor, I have stated before this honorable last date. Let me repeat it just to refresh our mind. That the accused person was arrested on this instant case on the strength of NBWA, Your Honor. The matter that has come out that after the investigating officer had filed the charge sheet before this honorable court, and then the accused has been discharged before the charge sheet. So on go through with the report at the time before framing the charge, and then this honorable court was pleased to implead the accused as one of the accused. So that was by order dated 28/11/2025 in my paragraph number 3, Your Honor.
Here goes.
Yes. And then, Your Honor, the accused person actually.
By which order?
By order dated 28/11/2023 in my in paragraph number 3 of my application. Okay.
28.
28. 28. Okay. 28/1.
2000.
2026.
Yes. Let's read the order. What is that?
In paragraph, I think the order 28/1/2026.
28.
In paragraph number 6, Your Honor.
28(1).
Yes.
No, read the order dated 19/11/2025.
19.
Yes.
Let's check whether I have it or not. I have.
Yes.
So I have only this 28. Let me see.
Who's appearing for the prosecution?
We appeal.
Yes.
Yes, 1911. No?
We didn't.
Charged in this case was filed on the behalf of.
Let's read about it.
Yes, Aramis Karan Alfonso.
No, read for me also. I don't know if the copy is there.
I'll just come in. Okay, let from me. Accused person Ramesh Kar is produced before this court today from the district prison and correctional home, Shillong, through VC. Number two, learned counsel for learned counsel Chri T Langpa for the accused Ramesh present. Accused person Sajan Udin present along with learned defense counsel Chri H Pakama. Learned additional public prosecutor Srimati S. Sancha present. This matter has come up for order. The facts and circumstances under which this case has come up for order is briefly recapitulated. Charged in the instant case was filed on the 31st August 2023, being CS number 51/2023. The charge sheet was filed against the accused Ramesh Takar under section 363, 302, 120B, 364, 394, 204, stroke 34 IPC, and against the accused person Sajan Udin under section 411 IPC. Further, the IO in the final report had prayed for discharge of the accused Telmi Porto and Bormi, alias Bormi, due to lack of evidence. The charges was laid before the court, before the committal court CGM, Jawai. The learned committal court white order dated 16/7/2025 was pleased to commit the case to this court as the defense is exclusively tribal by the session court. Sorry, not the defense, the offense. The committal order is silent with regard to the prayer of the IO for discharge of the accused Telmi Porto and Bormi. Be that as it may be, the case was committed to this court for the trial. This court, upon hearing the counsel for the accused Sajan Udin and prosecution, was pleased to add section 120B IPC against the accused. White order dated 27 August 2025. The accused Ramesh Khan had conceded to the charge before framing charge. This court had examined the charge sheet and found that there is strong evidence against Telmi Porto Bormi. However, a prayer was made for his discharge, which was neither accepted nor rejected by the committal court. This court was pleased to summon the IO to explain the circumstances under which prayer for discharge was made for the accused Telmi Porto and Bormi, alias Bormi. Then the IOSIP Najir apprised the court that the case was supervised by additional SP Kumari CW Lungdal. Thereafter, this court had fixed this matter for passing necessary order with regard to adding the accused Bormi Porto as an accused in the instant case. One of the prime accused in the instant case, I Love You Talang, was lynched by mob in jailbreak case. He was interrogated during the investigation. The case diary had the interrogation of the prime accused distinctly revealed the accused Telmi Porto was the mastermind in the instant case. He had planned hijacking of the vehicle and the execution of the driver to death. The IO in the charge sheet has revealed that the accused Telmi Porto alias Bormi was the mastermind behind the killing. He was arrested during investigation. Further, the IO has also revealed in the charge sheet that the accused Telmi Porto alias Bormi is an active participant in the disappearance and murder of late Fulmon Karchano along with the group of perpetrators. In the same breath, the IO has disclosed that there was no evidence of call record to manifest communication of I Love You Talang with Telmi Porto alias Bormi. From the charge sheet, it also emerges that the prosecution is heavily relying on the statement of the accused persons. There are other incriminating materials to show the involvement of Telmi Perto Bormi. This is a case where there is palpable evidence against the accused Telmi Perto alias Bormi. He has been shown as the mastermind of a crime in the charge sheet. Iconically, the prayer was made for discharge. An investigation commences with the filing of an FIR and it concludes in a final report. The investigation is in the domain of the investigating agency. After the conclusion of the investigation, the court comes in the picture. Once a final report is filed, the court may accept the final report or it may direct further investigation. Upon not being satisfied with the investigation, in even of the court accepting the prayer for discharge, the informant has a right to be heard on the prayer of the discharge of an accused. As such, notice of the informant is sine qua non before the accepting prayer for discharge. In the instant case, the committed court did not give any heed to the prayer of the IO for the discharge of the accused Delmi Perto alias Bormi. However, committed the case to this court for trial of the accused Ramesh Takha and Sajan Udin. The Learned Committal Court tactically accepted the prayer for discharge of the accused Delmi Perto and alias Bormi. This aspect of matter has serious implication which this court shall deal in the later part of the order. Whether a person who is not named in the FIR and later arrested as an accused during investigation and thereafter he is discharged from the case can be added as an accused. If there is sufficient evidence against him, is a question which calls for determination. Section 319 of CRPC deals with the question formulated above. Upon casualty regarding of the section 319, this court finds that the court is vested with the power to add a person as an accused during inquiry trial if it appears that the evidence that the accused has committed the offense and tried together along with the other accused. In the case in hand, the trial has not commenced. The matter is at the stage of framing charge. Section 319 of CRPC uses the words evidence. Evidence comes only during the course of the trial. Whether the word used evidence will also include the material in the charge sheet for the purpose of invoking power 319 of CRPC is a seminal question. On facts, there are sufficient material to show that the accused Telmi Perto alias Bormi is involved in the instant case. This court first has to cross the hurdle of law before delving into the facts. The question cropped up in the instant case is no more res integra. The constitutional bench of the Honorable Supreme Court in Hardip Singh versus State of Punjab, 2014, 3 SCC 92, has dealt with the power of the court under Section 319 of CRPC and the import of the word evidence under Section 319 of CRPC. The Honorable Court in the Hardip Singh's held that the object of Section 319 CRPC is to ensure real culprit should not get away unpunished, and when guilty is acquitted, the judge is condemned. So Section 319 requires constructive and perspective interpretation to advance the object and cause of injustice. Further, it held that the word evidence used in Section 319 CRPC has to be broadly understood, not literally as an evidence brought during the trial. However, the Honorable Supreme Court held that if an accused who has not been discharged, if he is added as a party by the trial court, subsection 5 of section 300 of CRPC needs to be complied with. The above statutory provision provides that when an accused is discharged under section 258 of CRPC, he shall not be tried again for the same offense, except with the consent of the court by which he was discharged. This is not a case where the accused is discharged under section 258 of CRPC. Further, the committal order has not made any whisper with regard to the prayer of the IO for discharge of the accused Telmi Porto alias Bormi. As such, section 300 will not come in any way of this court is exercising its power under section 319 of CRPC. The nature of satisfaction the court needs to arrive for involving section 319 to add a person as an accused finds place in the para 117.5 of Hardeep Singh. For easy reference, it is reproduced here. Though under section 19 clause 4 subclause B of CRPC, the accused subsequently impleaded is to be treated as if he had been an accused when the court initially took cognizance of the offense. The degree of satisfaction that will be required for summoning a person under section 319 CRPC would be the same as for framing a charge. The difference in the degree of satisfaction for summoning the original accused and a subsequent accused is an account of the fact that the trial may have already commenced against the original accused, and it is in the course of such trial that material are disclosed against the newly summoned accused. Fresh summoning of an accused will result in delay of the trial. Therefore, the degree of satisfaction for summoning the accused, original or subsequent, has to be different. So this court finds the material in the charge sheet, which can be construed as an evidence for the purpose of exercising a power under 319 of CRPC, manifest grave suspicion pointing towards the involvement of the accused Telmi Porto in the instant case. A strong case is made out of for adding the accused Telmi Porto alias Bormi in the instant case. The accused Telmi Porto Bormi is added as an accused in the instant case. Summon the accused person Telmi Porto alias Bormi. Prepare copies for the accused Telmi Porto. If the accused fails to appear, this court shall resort to subsection 2 of section 319 to secure the appearance of the accused person. Fix this matter for appearance of the accused person, Bormi Porto, and for copies. Accused Ramesh so and fix it on the 3rd of December 2025. Yes.
Then we should summon.
Yes, we should summon.
Then what happened?
Then when the summon was served, and then the accused at that time he had not appointed any lawyer, and he has no knowledge that he has been impleaded in this instant case. And then
Did you receive summon in this case?
I'm not aware with that, Your Honor. But he comes before the court on the 30th of June 2026 for the another case.
No, let's see, 319. after impleading him or adding him as an accused, we did not arrest him. All right?
Yes.
We had issued a notice.
Yes,
We
yes.
issued a summon to him. What happened to that summon? Was he served the summon?
Your Honor, I asked pardon before this court. I do have no knowledge about that. Because at that time, I was not engaged as a lawyer, as a defense for him, as a counsel.
All right. Once a person has been added as an accused, if he fails to appear, subsection 2 of section 319
Yes.
says that he may be arrested.
Yes.
So we arrested him.
We arrest him on the 30th of January 2026, Your Honor.
Yes. Yes.
We arrest him on this date. Actually,
We
what
come to that order when we arrested him.
on the 30th of
No, that order dated first when we arrested him. Give me the case call.
I think this order, let's say this handwritten order. No?
No.
30th 01/2026.
Yes, what is that? 38?
30th 30/01/26.
Yeah.
Yes. May I read it?
Yes.
Yes. See, case record.
No, I want to know that we had issued summon to him.
Yeah.
No, after adding him as an after
As
adding
an
him
accused.
we have issued summon to him.
Yes.
Why did we arrest him? What was the reason for arresting him?
See, as I may have submitted that.
No, we have arrested him on the strength of non-bailable warrant.
Yes.
That order dated 31/2026
Yes.
shows that he was arrested on the strength of non-bailable warrant issued by this court. Why, at the first instance, non-bailable warrant was issued against the accused? Why? Because
he fails to
after
appear.
after adding him as a party,
Yes.
we did not take any coercive steps
Definitely.
to secure his presence,
Yes.
nor any warrant was issued.
Yes.
We had issued summon.
Someone to-
So what prompted this court to issue non-bailable warrant against him after issuing
because
summon?
he has failed to appear.
Where is that order?
Order 28. 28/1. 28/1, Your Honor.
Yes.
The 28/1 in paragraph number 9.
Yes.
Yes.
Was summon served to him?
Yes.
Summon was served to him.
See, Your Honor, I'm not aware of that. I apologize from this because
Let's see if summon was served. If summon was served, we are not granting bail.
yes.
Summon was served. This where we issue summon. After this order dated 19 was summon. Where is the summon? You bore me put. Summon to the accused. Reason. But someone was given to his wife. Someone was given to his wife.
And that is why, Your Honor, I have inquired from his wife, but he's not willing to come even to be as a petitioner for him. because she said that after that, so he had come. We have released him in connection with this session case number 39/2014. And then after that, he is not. He has not. He don't want to cohabitate with him anymore. And that's why I'm lack of that information. But it was issued on the 28th, Your Honor, 01/2020, 26. But he on the 30th, 01/2026, he personally appeared before the case in connection with this case number 39/2014, Your Honor. NBWA order was order on the 28th, 01/2026. 2 days after he came, I have informed him. This is because that was it was supposed to file it was for a judgment, if I have not mistaken, on that case. So he came purposely for in this in connection with this case 39/2014.
No. After order dated 19, when we added him as a party in the instant case, 19/11/2025. The accused appeared before this court on 17/12. On 17/12, the accused appeared before this court.
Okay.
Copy of charge sheet shall be supplied to the accused. Accused Telmi Purtho, present before this court. All right. Fixed for hearing before consideration of charge. So he appeared. He knew that he is an accused in this case.
Okay.
So the matter is fixed on 31. 31, court was not there.
Okay.
Then again, the matter fixed on 14/1. 14/1, the court was not there.
28.
Then on 28,
Then the non-payable warrant has been issued against him.
there is passed in order for supply of copy and fixed the matter for the hearing. Yes. Then after that, accused did not appear. We issued non-bailable warrant by order dated 28/1/2026.
Yes.
He was arrested.
On
He did
the-
not appear.
Yes, he arrested on the 30th.
Yes.
2 days after.
Yes. Yes.
That means even the order also has not been served, but has not been served to him.
Yes.
Yeah, but the thing is that on the 30th, 2 days after the order, he came personally before the court in connection with session case number 39/2014,
Correct.
and that date was fixed for final judgment. So he came, and when he came, then the court took custody of the accused person.
Okay.
What I mean to say, Your Honor, I mean that the accused, he has no intention to avoid appearing before this honor.
He has.
No.
After being served summon pursuant to the order dated 19/11/2025, he appeared before this court on 17/12/2025. Thereafter, he failed to appear.
Yes. He failed to appear, Your
Yeah,
Honor.
it is only when we issued non-bailable warrant, he was apprehended. Not only apprehended, we had issued non-bailable warrant. Before the non-bailable warrant can be executed, he appeared before this court in connection with some other case. That non-bailable warrant was executed and he was taken into custody in this case. Now, this is not a case where the accused was arrested on the strength of non-bailable warrant. Okay, one. This is not a case where you are praying for bail of an accused persons who have been arrested during the course of investigation or during the course of trial. This is a case where the accused has been taken into custody. Initially, the court was not inclined to take custody of the accused after adding him as an accused in view of section 319 subclause 2, which
Yes,
gives
sir.
a discretion to the court either to arrest him or issue summon.
Yes, yes.
We had chosen to issue summon. He responded to the summon. He failed to appear. Thereafter, we took coercive steps to secure his presence and he was arrested on the strength of non-bailable warrant issued by this court.
Yes.
Now, why should we grant him bail now?
See, Your Honor, that on the strength of non-bailable warrant, which was issued on the 28/01/2026, yes, the accused person has no knowledge that he has to appear on that particular day.
No.
Had he known, yes, Your Honor, had he possessed that knowledge that he has to come and appear, definitely he will accuse to appear. Otherwise, if he intended to abscond, then he will not appear on the 2 days after.
No, look, if you say that he had no knowledge of for appearing before this court, he was no knowledge about he being added as an accused in the
Yes.
instant case. Order dated 17/12/2025 clearly says that in response to the notice issued by this court, he appeared before this court.
Yes, I
We
admit.
supplied him copy.
I admit.
It
Your
is
Honor.
not that he is not aware that he has
No.
been added as a party. If your
I-
argument is
no,
this,
no,
that
no.
he is not aware.
No, I
that
did
he-
not say.
Yes,
In my petition, I did not say that
Yes.
he was not aware.
yes.
But the thing is that I said that he has no intention to abscond from appearing of this honorable court. That is my humble submission. Why I say so? Because after he was added as the accused, then his summons was served, then he reappeared. Then after appeared on the next 2 days, on the 30 and the 14 something, this honorable court was not sitting, I think, and for that reason he might miss out the day. And therefore, we who are dealing this case, session 39 to stroke 2014, we had informed him to come on this day, and he had complied with that. So,
Okay.
so
Had he appeared before this court on the date fixed and he was arrested?
yes,
Let's see.
I was there.
No, he was arrested on 31/2026. The matter
Yes.
was fixed on 11/2/2026.
Yes, this in connection with the session case number, which has already disposed recently.
No. We are not concerned. We are not concerned with that case. He might have appeared before this court in connection with that case.
Mhm.
So appearance in one case does not necessarily mean that you have appeared for the other case. These are two different cases. You are standing for trial on a charge of two different cases.
Yes.
But we are more concerned about whether you have appeared before this court on the date fixed.
See, on that, as soon as I
So
received
far
the
as
command-
so far as your argument is concerned, that accused was not aware that he has been added as an accused in this case, that runs contrary to the record.
No, it's not. It's not in my petition that I have written that.
Okay.
I said that he has no intention to abscond for the reason is, as we have seen from the record, that after he had been added, someone has been served. He appeared before the court.
Yes.
And then after the next consecutive day, the court was not sitting, and for that reason, and then 14 days after it was fixed, on the 14th of 01/2026, the court was not sitting, and then on the 28th, that is after 14 days, and then he was the non-bailable warrant was issued.
Okay.
I mean, my submission is that, had the accused had the intention of not appearing before this court, he would not have come on that particular day, which is fixed on another day. As such, I said he has no intention.
Come to
As to
no. Very difficult to go on intention. Come to subsection 2 of section 319.
Okay, let me read.
Subsection 2 of section 319.
Let me read from.
Yes.
Where such person is not attending the court, he may be arrested or summoned as the circumstances of the case may require for the purpose of the aforesaid.
All right. That's what exactly we did.
Yes.
We had issued summon to him,
Summon.
and he was not appearing before this court. He was not attending this court.
First he attended.
That's what he was not attending the
First he
court.
attended, and then
No,
as we have.
is it a case that we had issued a non-bailable warrant against the accused person in spite of the accused person's regularly appearing before this court? No. He had appeared before this court, which is an indication that he was aware of the fact that he has been impleaded as an accused in the instant case. All right?
Yes.
Thereafter, if he fails to appear, it provides where such person is not attending the court, he may be arrested or summoned as the circumstances of the case may require for the purpose. We had issued summon initially.
Yes, definitely.
Thereafter, he was not appearing before this court.
Understood.
So what is to be done next? He is to be arrested.
To be arrested.
So we arrested him.
Yes, sir.
Now, why should we grant bail to him?
And for purpose, why? Why do we have to grant, and why do we have to come?
See, come to subsection 3. Any person attending the court, although not under arrest or upon summon, may be detained by the court for the purpose of inquiry or trial of the offence
Yes.
which he appears to have been committed.
Yes.
So he can be kept in
Yes.
custody.
It's, Your Honor,
Yes.
I have submitted,
Yes.
though he was arrested on the
That
street.
part finished. We have got it.
We have
Now,
got it.
why you should not?
But- but-
why, yes. Now, why you should not?
But
be detained?
after that, we have detained him. Charge was framed,
Yes.
and after the charge was framed, then the complainant had come before the court, and there's no incriminating against the accused person.
Yes.
And after 8 consecutive days, we had failed. Then the PW2 had come before the court. Then yet we examined and we found nothing which is incriminating during this stage, Your Honor. And as such, Your Honor, that he had been arrested from the 30 of January. Up to date, we have only examined 2 witnesses in this stand case. And then we have missed out the dates. And in this stand case, there are as many as 13 witnesses. Then all we have read from the copy that has been supplied, nothing which is incriminating him. And I said that there is a little bit delay due to the difficulty of tracing out the witnesses to depose before the court. And for that reason, I said, Your Honor, until these days, 2 witnesses we have examined and nothing which is incriminating against the accused person, though he may be arrested on the strength of non-NW, and I have stated that it was not with the intention. Then if this court were to release the accused person on bail, on any terms and condition, we shall provide a required reliable surety and a surety amount as deemed fit and proper by this honorable court, and he stays somewhere in Corelli, which is not far from this honorable court. And then we shall also ensure that he has to come each and every day that fixed by this court. Yes. And we have gone along for almost 7 months now.
Do you have witness?
Here we have one.
However, this accused also he is delaying the trial. And moreover, there are some important witnesses yet to be examined. Today also we have one.
What is examining?
And if he is released on bail, he might influence the witnesses because he can manipulate the evidence of not only in this case, here many cases. Therefore, I object to this bill as this stage.
Yes.
But see, regarding that the tampering, because all evidence has been collected by the submitted by the honorable court. In the honorable court is in the custody of the honorable court. There is no question for tampering with the evidence. Influencing of the evidence, there will be always like a strict condition to be imposed. And moreover, we have that witness today. We will examine the witness after that.
Decide the bail application. All right. This is a bail application. This is a bail application under section 483 BNS 2023 for the release of the accused Telmi Purthu alias Bormi Purthu in connection with session case number 14/2015 under section 120B/363/364/394/302/201/34 IPC. The application is supported by an affidavit and moved by learned counsel R.B. Hing. Heard learned counsel for the petitioner. Heard learned prosecutor Sri S. Chansang. Peruse the record.
One of the witnesses feeling the night before is quite small. So she's
No.
feeling,
All right.
I don't know whether she's weak or shaking.
All right.
You may take it to outside
Yes,
for
yes,
refreshing.
Yes. Take.
Let
Let him.
Let him refresh.
All right.
Because he has been sitting from
Yes.
from
Prosecutor, this court, that on perusal of the record, not peruse the record, that on perusal of the record, it emerges that this court, by order dated 19/11/2025, was pleased to add the accused. And I was pleased to add Bormi Portu Ilyas Ronsuso as an accused in the instant case. Consequently, summon was issued to the accused. Stop. The accused. The accused appeared before this court on 17/12/2025. Thereafter, on the date fixed, that is on 28/1/2026, the accused failed to appear. You don't have thereafter. On failure of the accused to appear on 28/10/2026, this court issued non-bailable warrant against the accused. The accused appeared. The accused was apprehended. The accused was arrested on the strength of non-bailable warrant and produced before this court on 30/1/2026. The accused was remanded to 12 days judicial custody. It is pertinent to mention that the accused was added. Bormi Portu was added as an accused at the stage of framing charge. After the arrest of the accused, charge was framed against the accused. Should be the evidence. Charge was framed against the accused. On 25 January, no. On 25th January 2026, on denial of the charges, charge was framed under section 364, 302, 392, 120B IPC. The prosecution has examined two witnesses. This court. No, two witnesses. Under the above facts and circumstances, the prosecution, the counsel for the petitioner submits that the accused has been in custody. How long?
145.
Accused has been in custody for almost 145 days.
It's more than because until the day, because on the last day.
145 days.
As on the date we filed the application.
145 days, almost 145 days. The trial is not proceeding expeditiously. The defense counsel the counsel for the petitioner, the counsel for the petitioner argued that detention of the accused is not required. There is nothing, there is no material on record to show that the accused is evading trial. Full stop. No comma. This is evident from the fact that the accused had appeared before this court in connection with some other case, and he was apprehended on the strength of non-bailable warrant. Full stop. The petitioner, the counsel for the petitioner prays for release of the accused on bail. Full stop. Next paragraph. Additional prosecutor Shri S. Chansang strongly object to the grant of bail to the accused and submits that the accused is an influential person he has demonstrated that he can manipulate the cases, he can manipulate the witnesses, which is evident from the fact that the accused, in spite of being involved in this case, he was discharged. Full stop. Next one. The prosecutor submit that the accused has criminal antecedent and has been implicated in many criminal cases. If enlarged on bail, he may pose threat to the witnesses. The prosecution prays for rejection of the bail application. Next paragraph. This court, upon hearing the rebel counsel and on examination of the material on the court, finds that this court, after adding the accused, adding Bormi Pothu, adding Bormi Pothu, as an accused, by order dated 19/11/2025, was pleased to issue summons to the accused. Which is an indication that this court initially was not inclined to apprehend the accused for the purpose of trial. The accused, after receiving the summons, appeared before this court, and thereafter he failed to appear. There is nothing on record to show that an accused against whom charge has been framed for a serious offense is on bail. Stop. If at all this court intends to secure the presence of the accused, his presence can be secured only through the sureties. Stop. This court had the opportunity to minutely examine the charge sheet and arrive at a conclusion that there were enough materials against the accused to prima facie show his involvement in the offense charge. In spite of those clinching evidence, the accused was discharged. Which speaks a lot about the investigation and the role of the accused. There are material to show there are no material to show why there are no material to justify discharge of the accused. This court finds force in the submission made by the defense, by the prosecution, that the accused appears to be a very influential person and has the capability to influence the witnesses. This court says so, as there is a prima facie material on record to show that he had diverted the investigation in his benefit Full stop. It would not be in the interest of justice. It would not be in the interest of justice and fair trial to enlarge the accused who has demonstrated, no matter how, who has demonstrated that no matter how serious is the offense, comma, no matter how much, no matter how serious is the offense, no matter how much, no matter how serious is the offense, or how strong is the evidence, he can evade and secure discharge. The accused with a strong criminal antecedent and material on record to show in spite of there being material nay, the accused with a strong criminal antecedents and a history of securing a benefit, a history of securing wrongful gain. The accused with a strong criminal antecedent and a history of securing wrongful gain cannot be allowed to be at large at this stage. Bail application is devoid of merit and dismissed. Yes, bring it. Yes.